Witness mic 1. Witness mic 1. Witness mic 1. Witness mic 1. Witness mic 1.
The Subcommittee on Health, Employment, Labor, and Pensions will come to order. Welcome, everyone. I note that a quorum is present. The subcommittee is meeting today in a hearing to receive testimony on protecting workers' rights to organize, the need for labor law reform. Pursuant to Committee Rule 7C, opening statements are limited to the chair and the ranking member. This allows us to hear from our witnesses sooner and provides all members with adequate time to ask questions. I recognize myself now for the purpose of making an opening statement. Today's hearing is an important opportunity to examine the threats of workers' rights and explore proposals that will improve the quality of life for millions of workers and their families. America's unions are engines of economic mobility. For generations, they have fueled our nation's prosperity, protected the health and safety of American workers, and supported a strong middle class. Beyond fighting for better wages and benefits, unions safeguard equal pay for equal work. They advocate well beyond their membership to ensure that all workers can achieve economic mobility. As Congress considers measures to close the wage gap for women and people of color, unions play an essential role in fostering pay equity. Strong unions played a central role in building a robust middle class in this country, and they are essential to rebuilding it again. Simply put, if you claim to back the interests of working people, you must also be pro-union. The right to join a union is an internationally recognized human right. Unfortunately, the combination of weak labor laws, intensification of employer opposition to unions, and relentless political attacks have driven union membership to historic lows. Roughly a third of American workers were in a union in 1956. Today, just 1 in 10 workers is in a union. This shift has had widespread consequences for working families and the middle class. I call your attention to the charts. As union membership decreased from 27.1% to 11.1% between 1973 and 2015, the share of income going to the top 10% skyrocketed from 31.9% to 47.8%. Over the past decades, wages for the typical worker have stagnated. The link between rising productivity and higher pay has been broken. When union membership hovered around 30% between the end of World War II and 1973, wage growth was in lockstep with increased productivity by over 90%. However, between 1973 and 2017, productivity increased by 73%, but wages have only grown by 12.3%, adjusting for inflation. Let me underscore this important point. The decline in union membership has eroded the link between growing productivity and rising pay. It has stagnated wages for American workers. Inequality and wage stagnation are not natural products of a functioning economy. They are the result of policy choices that have stripped workers of the power to stand together and bargain for fairer wages, benefits, and working conditions. We have seen this consistently in the Trump administration's policy decision as President Trump has sided with big corporations at the expense of workers and unions. Under this administration, the National Labor Relations Board has empowered employers to gerrymander and interfere in union representation elections, misclassify employees as contractors to deny them their rights, and retaliate against workers who exercise their First Amendment rights. This is simply unacceptable. That is why, during the last Congress, committee Democrats introduced legislation to ensure that workers have strong bargaining rights and protections from unscrupulous employers. This Congress, the committee will continue the effort to strengthen labor laws so that workers can stand together and negotiate for a fair return on their work. Today, we will explore the strengths and weaknesses in the current state of labor law and identify proposals that hold employers that violate the law accountable, protect collective action, and modernize labor laws for a changing economy. If Congress is truly on the side of American workers, then we must protect their right to bargain for better wages and better working conditions. This hearing is an important step towards that goal. I want to thank all of our witnesses for being with us today, and I look forward to your testimony to enlighten us. I'll now recognize the distinguished ranking member for the purpose of making an opening statement. Ranking Member Wahlberg.
I thank the chairman and appreciate the opportunity to make this statement and be part of this hearing today. While we agree that federal labor law is in need of reform, the title of today's hearing, with all due respect, is premised on a fallacy: that workers' right to organize and join a union is in some way in jeopardy. Federal law protects workers' rights to unionize point blank. Becoming a union member is an important and personal decision, and Republicans and Democrats alike respect the right of employees to decide for themselves whether union membership is right for them. It's personal for me too. I grew up in a union household. My father was a machinist and tool die maker who spent part of his working career as a union organizer. When I graduated from high school, I went to work at the same steel mill on the south side of Chicago. It's important that we have a level playing field and workers receive good pay for a good day's work. But times have changed since my father was organizing in the workplace. Since 1983, union membership has steadily fallen from over 20% to just 10.5% in 2018 and less than 7% in the private sector. Of the workers that are still represented by unions today, almost none, like me, when I was a member of the union, ever actually voted for the union that represents them. This is America. It seems straightforward that the best way to reverse the downward trend would be through increased transparency and working to better serve their members. Instead, we've seen calls for labor laws that would empower union interests and allow those at the top, to further consolidate power. There's no question that the National Labor Relations Act, NLRA, and Labor Management Reporting and Disclosure Act, LMRDA, are in need of targeted reform. However, the answer should not be to alter these laws in a way that tilts the balance of power towards special interests at the expense of the hardworking men and women who drive our economy. Let's not forget, the last time Democrats held a majority in the House, they voted to deny workers the right to a secret ballot in union elections. In 2015, the Obama Nlrb implemented a rule that gives workers as few as 11 days to decide whether or not to join a union and do the research necessary for their best interests. The Obama board also ruled that employers must hand over employees, and get this, none of us like this, hand over employees' private information like home addresses, phone numbers, and work schedules, aiding well-documented efforts to harass, intimidate, and pressure workers into supporting the union. Private information. Workers deserve the right to make free and informed decisions about joining a union. And reforms to the NLRA and LMRDA should put workers, not union leaders, first. That's why Republicans have introduced numerous pieces of legislation in recent years that would protect and expand workers' rights within their union and increase financial transparency so workers can see with greater detail how unions are spending the dues taken from the workers' hard-earned paychecks. American workers have greater opportunities today than they have in decades. Wages are rising. That's a fact. Unemployment is at near record lows. Back to the days that I worked at the U.S. Steel. And millions of jobs have been created since President Trump took office. There are help-wanted signs everywhere I go across Michigan. With so many good-paying jobs waiting to be filled, we need to develop a skilled workforce and equip our people with on-the-job experience. As this economy continues to thrive, our focus should be on expanding pro-growth economic policies that create the best path forward for union and non-union workers alike. And I yield back.
Without objection, all other members who wish to insert written statements into the record may do so by submitting them to the committee clerk electronically in Microsoft Word format by 5:00 p.m. on April 9, 2019. I will now introduce our witnesses. Dr. Jake Rosenfeld is an assistant professor at Washington University in St. Louis, Missouri. Welcome. Ms. Cynthia Harper is a lamination specialist formerly employed in an automotive glass plant, and she is from Englewood, Ohio. Welcome. Mr. Glenn Tobman is a staff attorney at the National Right to Work Legal Defense Foundation. Welcome. Ms. DeKeeverk is a member of the law firm Bridhoff and Kaiser. Welcome. We appreciate all of the witnesses for being here today, and we look forward to your testimony. Let me remind the witnesses that we have read your written statements. They will appear in full in the hearing record. Pursuant to Committee Rule 7D and committee practice, each of you is asked to limit your oral presentation to a 5-minute summary of your written statement. Let me also remind the witnesses that pursuant to Title 18 of the U.S. Code, Section 1001, it is illegal to knowingly and willfully falsify any statement, representation, writing, document, or material fact presented to Congress, or otherwise conceal or cover up material fact. Before you begin your testimony, please remember to press the button on the microphone in front of you so that it will turn on and the members can hear you. As you begin to speak, the light in front of you will turn green. After 4 minutes, the light will turn yellow to signal that you have 1 minute remaining. With that, when the light turns red, your 5 minutes have expired, and we ask that you please wrap up. We will let the entire panel make their presentations before we move to member questions. When answering a question, please remember to once again turn your microphone on. I will first recognize Dr. Rosenfeld.
Madam Chair Wilson, Ranking Member Wahlberg, and all members of the subcommittee, thank you for the opportunity to testify today about the benefits collective bargaining has on our workforce. My name is Jake Rosenfeld. I'm an associate professor of sociology at Washington University in St. Louis, and for the past 15 years, I have conducted quantitative research on the linkages between strong unions and economic equality in the U.S. and how union decline has contributed to widening income disparities in our economy today. The unionization rate today is at its lowest point in over a century. It is as low as it was prior to passage of the National Labor Relations Act, a law intended to guarantee workers the right to bargain collectively with their employers. This dramatic decline has far-reaching implications for our workforce. From my own and related research, I wanted to share 4 key findings with you today. First, there's an accumulating body of research from across the social sciences that finds that strong unions were a key factor in delivering widespread gains to millions of working and middle-class Americans during the post-World War II decades. Their decline explains much of the subsequent rise in income inequality. One influential study I co-authored with Bruce Western finds that the fall in union membership explains about 1/3 of the rise of income inequality among men and about 1/5 of the rise among women. A recent study by economists at the International Monetary Fund links diminished union power to rising incomes at the very top of the distribution. The implication from the IMF report is that union decline has allowed the rich to get richer and contributed to stagnant and falling incomes for nearly everyone else. And this includes non-union workers. The second finding I want to share with you today stems from new studies that reveal just how important unions were to the economic standing of non-union workers. In a 2016 study with Patrick Denise and Jennifer Laird, we examined over 3 decades of data on millions of American workers who do not belong to a union and found that weekly wages for non-union men would be about $50 higher if unions today remained as strong as they were in the late 1970s. For a year-round worker, this translates to an annual wage loss of about $2,700. In a follow-up study, we find that the effects of union decline on non-union pay remain after adjusting statistically for other key determinants of wages in the modern economy, including rising skill demands, demanufacturing, and automation. Third, when and where they were strong, unions were especially important for the economic standing of racial and ethnic minorities and women workers. Nationally, union representation rates for African American men in the private sector rose to nearly 40% by the early 1970s. And by the end of the 1970s, nearly 1 out of every 4 African American women in the private sector belonged to a union. In this country, we had nearly closed the racial wage gap among women by 1980. The destruction of private sector unions from the 1980s onward widened it once again. My research indicates that had union membership rates for women remained at late 1970s levels, racial wage inequality among women in private sector jobs today would be lowered by as much as 1/3. Other research has established that gender pay gaps are much smaller in the unionized sector. The labor movement's upsurge between the Great Depression and World War II relied heavily on immigrants and their children. Echoing this historical pattern, my research reveals that more recent arrivals are joining unions at high rates in those sectors where organized labor remains powerful. But those sectors are obviously shrinking. Unlike past generations of immigrants who once swelled the ranks of the organized workforce, recent immigrants face an economic and political context that's now largely hostile to unions. As a result, contemporary immigrants and their children enter labor markets largely lacking a proven pathway to the middle class that unions had established. Fourth and finally, it's time to dispel the myth that U.S. workers have turned away from unions. In 2017, researchers at MIT surveyed nearly 4,000 U.S. workers. They asked the non-union workers whether they would vote for a union if given the opportunity, and nearly half replied yes. If the private sector unionization rate were simply a function of workers' desire, it would be much closer to 50% than its current rate of just above 5%. And a recent Gallup poll found that support for labor unions is at a 15-year high, with nearly 2/3 of Americans expressing approval. This is what makes strengthening the National Labor Relations Act so important. Today, workers are often blocked from exercising their legally guaranteed freedom to negotiate. Inequality has reached heights unscaled since the first Gilded Age. These two trends are intimately tied, and if we are serious about combating the latter, it is past time to do something about the former. Thank you.
Thank you, Dr. Rosenfeld. We will now recognize Ms. Harper.
Thank you, Madam Chair Wilson, Ranking Member Wahlberg, and members of the committee for the opportunity to testify today. My name is Cynthia Harper. I live in Englewood, Ohio. I worked as a lamination specialist at Fuyao Glass of America in Moraine, Ohio, from May of 2015 to October 2017, where we made automotive glass. I also worked at that same plant for General Motors Truck and Bus for 14 years. My job was strenuous and dangerous. I worked in the stretch room loading polyvinyl butyrol lamination into the machine and then putting measurements in the computer. There was no lockout tagout policy in place, which is a step that shuts down the computer when maintenance needs to be done. Not only is this dangerous for workers not having this policy, it is illegal. There were no overhead mirrors in the aisles or pedestrian lanes. Forklift, golf carts, and people were all using the same lanes, causing mass confusion and fear that someone would be killed accidentally. Numerous of occasions, I witnessed people almost getting hit by forklifts because they were not properly designated. Workers were also handling hazardous material with no safety equipment. When I cut PVB, I worked with a homemade knife that consists of a blade and some leftover PVB. We were not allowed to wear gloves, and someone was cut almost every day. Management said they didn't use gloves, and we needed no gloves because our hands could properly line the glass. It was no emergency exit in the room, and if it was a fire, we would have no way to get out. Our safety concerns were not being addressed. I believe if we had a union, the plant would be safer and more fair across the board. At the end of the day, we all wanted Fuyao to be a better and safer workplace for everyone. A union would have given us a voice on the job and also a say in our safety and health improvements. When the company found out we were trying to organize a union, some workers were fired. Workers on the VOC committee were prime targets of the company and were fired. In meetings, management would threaten that if we had a union, they would move their business elsewhere. Fuyao also paid an outside company to come in and hold small mandatory group meetings. They told us in these meetings negative things about the UAW. They told us if we signed a UAW union card, we would be signing our life away. I found out later that Fuyao hired Nlra, an outside company, and paid them almost $800,000. But our starting pay was only $12 an hour. I was a strong supporter of the union, and management knew it. They saw me handing out handbills at the front door, inviting people to come to our meetings. I wore my pro-union shirt. I was in the media, and this is all within my right, according to the Nlrb. I also was identified as one of the people that filed the complaint against Fuyao with OSHA. OSHA fined them on numerous of those fines, and they were fined on the violations. The company retaliated against me. In April of 2017, they demoted me to a lower paying job that was more physical demanding, and they told me that I had to do the job by myself when it was previously a two-man's job, or either get fired. My new job was a bubble repair job where I had to check for buttons. I had to lift glass that weighed almost up to 100 pounds. And the glass was taller and bigger than I was. It was physically tough. In June of 2017, I hurt my back on the job. I was fired after going out on medical leave because they allegedly said that I used my available time. I was fired days before the UAW filed a petition to unionize. Unfortunately, the anti-union campaign worked. The people feared their jobs, and at the end of the day, we did not get a union. My story and experience is not isolated or unique. The system is unfairly stacked against workers like myself trying to organize a union. I just wanted a fair shake and a voice on the job. I feared that I would die or not see my family because of the major health and safety issues that were not being addressed by the company. I believe that workers should have the freedom to form a union and not fear losing their jobs for support of a union. More enforcement needs to be done. The current law is not working. Workers need more protection. I look forward to your response, to responding to your questions. Thank you.
Thank you, Ms. Harper. We will now recognize Mr. Taubman.
Chairwoman Wilson, Ranking Member Wahlberg, and distinguished committee members, thank you for the opportunity to appear before you today. I have been practicing labor and constitutional law for over 35 years for individual employees only at the National Right to Work Legal Defense Foundation. I believe I have a unique perspective that comes from over 3 decades of representing thousands of private sector employees covered by the National Labor Relations Act. The announced topic of this hearing is the need for labor law reform, and I agree that federal labor law should be reformed to better protect individual liberty and safeguard individual workers' free choice concerning unionization. No worker in America should be threatened with discharge from his or her workplace for refusing to pay dues and fees to a private organization he or she may despise. No worker should be forced to be represented by a private organization and its officials who perform poorly in the workplace, who place their own interests above those they purport to represent, or who act corruptly to steal from the very employees they claim to represent. No worker should be forced to subsidize, as a condition of employment, the political schemes and candidates of a private organization of which they disapprove. Yet this is the reality for millions of private sector workers today under the compulsory dues and monopoly bargaining regimes of the National Labor Relations Act. Because labor unions under the NLRA do not have to stand for periodic recertification, authoritative estimates show that 94% of workers unionized under the NLRA have never voted for the union representing their workplace. Perpetually encrusting a labor union onto a workplace with no showing of current employee support does not lead to workplace stability and does not protect individual employees' freedoms of speech and association. There are several other current problems with the state of American labor law. First, current law makes it far easier for employees to form and join a union than it is for those same employees to choose to decertify the union. For example, the National Labor Relations Board maintains a startling array of non-statutory election blocks and bars that prevent employees from obtaining a decertification election. The board's current blocking charge rules effectively halt decertifications in at least 1/3 of the cases. Although all of these bars apply to prevent employees from decertifying a union, none of them apply to prevent employees from certifying a union under the 2014 Obama NLRB's ambush election rules. Number 2, another major problem with the labor law is that of forced dues and forced exclusive representation. It is neither fair nor constitutional to force employees into paying dues to a private organization upon pain of discharge, as the Supreme Court held just last term in Janus versus AFSCME. Similarly, forcing an individual to be represented by a private organization is antithetical to American values of free speech and association. Just as few on this committee would approve of being forced to be represented against their will by a lawyer or accountant purporting to serve as their exclusive representative for purposes of dealing with the government, few employees want to be forced into an exclusive agency relationship with the labor union for purposes of negotiating their wages and working conditions. 3, even in right-to-work states where employees have free choice to refrain from union membership or dues, it is usually very difficult for employees to stop paying dues. Union officials write dues checkoff cards in microscopic fonts and in language designed to be as confusing as possible. They make it difficult for employees to exercise their free choice. 4, 30 years after the Beck decision, union officials continue to thumb their nose at that decision and continue to force employees to pay for political advocacy and candidates over the objections of non-members. This leaves non-members like registered nurse Jeanette Geary little choice but to fight decade-long legal battles to protect their legal rights. In closing, I wish to reiterate that the NLRA needs serious and prompt reform to protect employee free choice and increase union transparency. For too long, union officials have been empowered by federal law to gain representational rights without a secret ballot election and force employees to accept union representation and pay unwanted dues or be discharged from their jobs. Thank you for your attention. I look forward to answering your questions.
Thank you, Mr. Taubman. We will now recognize Ms. Verk.
Good morning, Chairperson Wilson, Ranking Member Wahlberg, members of the committee. I appreciate your inviting me to appear here before you today to address the need for reform of the National Labor Relations Act, and in particular, protecting workers' rights to organize. The purpose of the act, as declared by the Congress that passed it, is to actively encourage the practice and procedure of collective bargaining by protecting the exercise by workers of full freedom of association, self-organization, and designation of representatives of their own choosing for the purpose of negotiating the terms and conditions of their employment or for other mutual aid or protection. That is a direct quote from the preamble of the statute. And the drafters of the NLRA were well aware that meaningful self-organization and collective bargaining could not take place within a system where, as Congress put it, there existed substantial inequality of bargaining power between workers and employers. The Act addresses this problem procedurally by creating a framework, a set of ground rules, essentially, that Congress thought would allow workers and their employers to engage on more equal footing. In the American system of at-will employment, an employer enjoys substantial unilateral power to set the conditions of employment. Employers offer jobs on particular terms. Workers decide whether to accept those terms or to move on and find a different job. Few workers have real ability to negotiate terms one-on-one with a potential employer. Further, if the employer changes the terms, workers can choose to stay and work under those terms or leave and find another job. But what the NLRA envisions and what it creates is a third option, entitling workers to choose to have a meaningful voice in setting their own working conditions. Unfortunately, in the decades since the NLRA was passed, this promise has not been kept. Interpretations of the law have diminished, burdened, and severely undermined the fundamental rights of workers, the right to self-organization and self-determination, the right to bargain collectively, the right to insist on better conditions, to publicize disputes, and to strike in support of what the workers believe that they deserve. For many workers and unions, far from being a source of rights, the NLRA is a legal minefield that they would rather avoid. Indeed, one could argue that much of the statute's remaining potency lies in its enforcement of employer rights and its protection of employer prerogatives. In fact, in my experience as a labor law practitioner representing workers and their organizations, even when the current NLRA scheme works as well as it can, it falls dramatically short of the promise of the Act. In one case I handled, workers voted for the union by a 2-to-1 margin, but due to post-election objections and appeals, certification was not issued until almost 9 months later. Then the employer stalled, refused to come to the table, and finally bribed employees to sign a petition saying they no longer wanted the union to represent them, and withdrew recognition exactly 1 year after certification had been issued. We filed charges, there was a complaint, the board even authorized an injunction, and won in court. Of course, the order issued by that court, which was the only order that it could issue, was an order directing the company to recognize and bargain with the union. No penalty, no damages, nothing else. And even under that expedited process, the order didn't issue until 2.5 years after the workers had voted overwhelmingly for the union. In another case, workers at a manufacturing facility had a stable bargaining relationship that had lasted for decades. Then the employer changed hands. The new spokesperson began bargaining by telling workers that in his eyes and the eyes of the employer, there was no contract, and bargaining would begin from scratch. They rejected the union's proposals with no explanation, took irrational positions, and insisted on concessions, including big cuts to employee health care. And when the union refused to agree, the company simply implemented its proposal. Some workers, faced with huge premium increases and copays, were forced to forego office visits and ration medication for their children. The board issued a complaint, a hearing was held, and a year after the company forced its offer on the workers, charges were sustained. But the company appealed, and faced with a choice between waiting for justice, likely years away, and addressing the urgent needs of members, the union returned to the bargaining table and reached an agreement. These are examples of the system working. It is time to rebuild the NLRA in the image that Congress first conceived. Workers should be able to decide promptly if they want a union to represent them. They should not have to be subject to employer anti-union captive meetings as a condition of employment, and they should not have to wait years to obtain an order of reinstatement if they are fired. Employers who violate the act should face meaningful penalties and to comply with employers' orders promptly. The importance of a right is measured, at least in part, by how simple it is to exercise and how seriously we take its violation. The signal has been sent to workers and employers that workers' rights to organize and act collectively are not worth very much. That decidedly was not the message that Congress meant to send when it enacted the NLRA. But at this point, if we want to change that message, we need to change the law so that workers who want representation on the job have an effective procedure to obtain that representation and an effective system to enforce the rights that the law provides. Thank you for your attention. I look forward to your questions.
Thank you, Ms. Burke. We will now proceed to member questions. Under Committee Rule 8A, we will now question witnesses under the 5-minute rule. I will now yield myself 5 minutes. Ms. Harper, I understand that you worked at the plant before it was bought by Fuyao, and during that time you had a union. Can you compare what it was like working at the plant when you had a union and what it was like without a union?
When I worked at General Motors Truck and Bus with the union, we had a safety committee, we had a ergonomic committee, we also had a seniority rule that if you had time in that you could bid for jobs and then get the jobs. It was a nice environment because we had a suggestion process where we could make suggestions on how the person that was actually operating the job could make the suggestion on how to improve that job. That was the benefit of having a union. At Fuyao, not having the union, we had a lot of safety issues, which I listed in my testimony. And it was pretty much a fear going in every day on whether you were going to go home safe or see your family because of all of the things that were out of place in there. The job, they would put you on whatever job they wanted to, take you off of a job even if you were the senior person. But the most important thing, at the end of the day, we wanted to go home to our families and make that place a better place. So not having a union was very unfortunate, and I know that it still persists because in 2018, one of the co-workers we had there was crushed in between a ton of glass, and that was one of our safety concerns, that we feared the way they had us loading that glass and the forklift drivers getting off and then standing between the glass. So that was the difference.
I want to thank you for being here today, Ms. Harper, and for telling us that story. And believe me, we on this committee will fight for you and all Americans who exercise their rights to negotiate for better pay, safety, and better working conditions. Thank you. Dr. Rosenfeld, your testimony cites 2018 polling data from Gallup indicating that 62% of Americans approve of unions. An MIT survey found that almost 50% of non-union workers would vote for a union if given the opportunity. How do you explain the gap between the large percentage of workers who would like to be in a union and the fact that around only 6% of private sector workers have a union today?
That's a great question. Thank you for it. So I think as Ms. Harper and Ms. Burke so aptly summarized, right now the law as it's currently applied actively encourages lawbreaking on the part of employers. So we know from other data that between a quarter to a third of all unionization drives include the unlawful firing or otherwise disciplining of union supporters and union organizers. And you combine that with all the lawful ways in which existing law is tilted in employers' favor, and you have this present situation where millions of American workers cannot exercise their legally guaranteed right to organize. And that's why I think updating the National Labor Relations Act for the present realities of today's workplaces is so important.
Thank you. Ms. Burke, we can all agree that when an employer breaks the law, they should be accountable for their actions. but the National Labor Relations Board has very limited power to enforce the workers' rights it is charged with protecting. In your experience, what have you found to be lacking in the NLRB's current enforcement powers? And what can Congress do to deter companies from engaging in illegal behavior?
Well, I think in the written submission that I made to the committee, there's a quote from a Supreme Court case nearly 50 years old now called H.K. Porter, which says and acknowledges the limited remedial powers that were granted to the National Labor Relations Board upon the founding of that board and the passage of the act in 1935. And what the H.K. Porter Supreme Court said was that if we want that to change, Congress needs to act. That's not something that the judiciary can do. That's not something that the board itself can do by regulation. Just to illustrate, and I provided a few illustrations in my oral testimony, a substantial number of violations of the act by employers are remedied solely with a notice posting. That is literally if an employer fails to bargain in good faith, like the court in the case that I described found the employer in that case had done. The entirety of that remedy in that case was for the employer to be ordered to go back to the table and bargain with the union. That's it. Literally a posting in the workplace saying, we will not refuse to bargain in good faith. In other words, go forth and just don't do it again. That is not an effective consequence for breaking of the law. And it tells an employer, and it tells, more importantly, the workers who are attempting to organize, that the rights that they have been deprived of by the employer's violation are not important. Because if there is not a consequence attached to that violation, there can be no change in behavior that we can reasonably expect. That's just simply one example. In terms of other remedial deficiencies in the Act, those are documented both in my submission and elsewhere. The lengthy delays between the time a person gets fired illegally during an organizing campaign and the time that even if they prevail, they're reinstated, that can be years. And by that time, the organizing drive that they were aiding itself is either broken or has been substantially diminished. So the employer in that case has accomplished the purpose that it set out to do when it acted with animus in firing somebody, and that is to prevent and scare the employees from joining a union and voting to have an effective voice on the job. That damage has been done, and it cannot be remedied years later by a reinstatement order. Those are just a few examples.
Thank you. Thank you so much. I now recognize our esteemed Ranking Member Wahlberg, for his round of questions.
Thank you, Madam Chairwoman. And thank you for the panel for being here. And Ms. Harper, I may make further statements in closing, but your story, as told, evidences the reason why there needs to be choice, there needs to be opportunity, and it has to be free and fair. And that laws that are in place, regardless of whether amendments are needed, and we certainly would recognize that over time there are, have to be followed. And your case illustrates it very clearly. I say thank you for sharing it. Mr. Taubman, thank you for being here. The Department of Labor has prosecuted union bosses for embezzling well over $100 million in workers' union dues since 2001, including most recently, sadly, in my home state with the United Auto Workers union scandal that was wide and far-reaching and sad to see the impact that it's had on union workers. Clearly, we can't take for granted that union leaders always act with honesty and integrity toward their union rank and file. The Labor Management Reporting and Disclosure Act is intended to allow workers to see how their dues are being spent by union bosses. Unfortunately, the Obama administration rescinded rules that would have improved union financial transparency under LMRDA. I believe that Congress should codify those improvements into law. Based on your experience, why do you believe it's so important for workers to have this financial information available to them about their union?
Thank you, Congressman Wahlberg. One of the reasons for the decline of workers choosing unions is the prevalence of these kind of financial transgressions that we see day after day. As you've said, the Department of Labor, you can just go to their website and see a constant stream of abuse of workers, abuse of the money that workers are forced to pay, because basically absolute power corrupts absolutely. So it is very important to strengthen the LMRDA reporting requirements. Employees come to me on a daily basis and ask me about how unions are spending their money, and when we go and look at the LM2s, the main financial disclosure reports that unions are required to file, they're very, very cursory. They don't provide any details. It's impossible for someone to look at these disclosure documents and see what the union is actually doing with their money. So all of this creates a culture of no accountability. I would also add, the National Labor Relations Board just ruled in a case of mine called Kent Hospital, Jeanette Geary. It's referred to in my written statement. And in that case, the union refused to give these employees a copy of its audit. It took a 10-year legal battle for these employees to get a copy of the union's audit, which they still haven't gotten because the union hasn't yet complied with that decision. So if you want to know the bottom line, employees need to know what the union is doing with their money, especially in situations where they are being forced to pay this money or face discharge.
I mean, it's a sad display either way, whether an employee doesn't have transparency or the employer isn't able to have the transparency as well to deal with. Let me ask a final question here. The NLRA protects workers from being fired, disciplined, or otherwise harmed by their employer for seeking to unionize, as the law intends. But no such rules exist to protect workers from union coercion and intimidation when trying to decertify their union. What other inequities exist between the union certification and decertification process?
Right. Well, as I said in my statement and in some of the written material as well, the labor law is slanted to get unions in power and keep them in power. It is very difficult for employees to mount a decertification campaign in the face of entrenched union power in the workplace. Now, these employees have lived with the union. Maybe they've lived with the union for decades, and then they say, you know what, we want a vote. All we want is a vote. People vote for all of the congressmen in this room on a 2-year basis. So employees say, all we want is a vote. And what happens is, suddenly there's a raft of what's called blocking charges that get filed, or suddenly there's Nlrb doctrines, all kinds of bars, the successor bar, the voluntary recognition bar, the settlement bar, a whole raft of crust that has been placed on the National Labor Relations Act over these years that prevent employees from just getting a simple vote. And that's one of the major inequities, because none of these bars apply when a union is seeking a certification.
Thank you. I yield back my time.
We will now go to the members for questions. Ms. Wow.
Thank you, Madam Chairwoman. Good morning. I'd like to start with Ms. Verk and ask you some questions about employers' standing, all right? When a union files for an election, the employer, as I understand it, is considered a party to the election and can litigate issues involving the scope and timing of the election. Is that correct?
That is correct.
And is the employer on the ballot when employees vote on whether to have union representation?
The employer is not on the ballot. It is either union or no union, or if there's a contest between more than one union, both unions will be listed on the ballot. But employers, certainly in my experience, have approached the process as if they were on the ballot, and that a vote for no union is in fact a vote for the employer, and they attempt to try to convince employees through a variety of means, some of which are lawful and coercive, some of which are unlawful, to attempt to vote against having a union. But that's correct. The employer is not technically on the ballot, but most employers, many of them, act as if they are.
So where is it in the NLRA that an employer is given the right to litigate an election when they're not on the ballot?
Well, as I understand it, it's actually not in the text of the act itself. I believe it's Section 9 that identifies the process for choosing a representative and for workers to choose a representative, and it speaks in those terms: employees' choice of representative for the purposes of collective bargaining. There's no mention of the employer expressly having standing in that process, in the text of the act.
And am I correct that employers lack standing when workers file for an election under the Railway Labor Act? Is that correct?
I believe that is correct, yes.
And do you believe that employers have a due process right to have standing in such elections?
I know that that argument has been made. To be honest, I don't know whether any court or whether the board has considered that issue.
Do you believe they do?
I don't think that they are granted that right by the text of the act. Whether there's a constitutional due process claim or not, I'm sure they could argue that. I believe that they should not have it.
Thank you. Ms. Harper, I'd like to just ask you, when your employers, you have indicated in your written testimony that you were active in trying to disseminate information about workers' right to unionize and so forth. Can you explain or describe for us what sort of actions were taken by your employer in response to efforts to unionize?
Some of the actions were the mandatory meetings that we had that would tell us the negative things about a union. In just our department meetings, they would threaten that if we had a union, they could move their business elsewhere. People that were part of the union, like me, I was demoted and then placed out in front of everybody for them to see on a job that was a two-man's job. So they did a lot of intimidation that way.
And do you believe that your coworkers understood that your demotion was related to your efforts to unionize?
Yes, I do, because I had a lot of them that were afraid to even talk to me inside the plant, but they would meet me at gas stations outside the plant to talk about the issues they were having in their department, but they were afraid because they needed their jobs. I also had a man that met me outside of there to tell me that management forced him to sign a statement against another employee that was on our VLC committee that in turn got fired behind that statement. And he was afraid, but he needed his job because that was his livelihood.
And are you still in touch with your former co-employees?
Yes.
And do you know anything about whether safety conditions at the plant have improved at all since you left?
They have improved, but a lot still exists, and they tell me all the time they wish we had a union.
And you described an incident involving an employee who was actually killed on the job?
Yes,
And that was back in March of 2018?
yes.
And you learned of that from another employee, or how?
No, it was news, it was public news.
I yield back. Thank you.
Thank you. Dr. Rowe?
Thank you, Madam Chairman, and appreciate that, and thank everyone for being here. Look, the most productive worker in the world is the United States worker, employee, no question about it. My dad was one of them, a union member. Worked for B.F. Goodrich Company making heels for shoes, and did after World War II. He lost his job, was outsourced to Mexico, and Dr. Rosenfeld, I appreciate your research, but I think it's a little more complicated. One worker in four, 1960, was in manufacturing. Today, less than 8% of Americans are. In 2016, we lost 20,000 manufacturing jobs, and thank goodness President Trump has tried to bring these back. We've added 600,000 manufacturing, good-paying jobs for American workers, and I think that's one of the problems we lost, where we lost wages. You mentioned that. I think that absolutely contributed to it, and seeing those jobs come back is a great thing. And I just looked, I remember I chaired this subcommittee for 6 years, and if I remember correctly, the average time to unionize is 35 days on average. I dropped a bill yesterday called the Employee Rights Act, and I want to look after the employees. It requires a majority of all union members, not a simple majority of those who cast ballots, to unionize. And this one is very near and dear to my heart because I put a uniform on, left this country over 40 years ago to protect the most sacrosanct right we have, and that is a secret ballot. Every single one of us up here was elected by a secret ballot. And if you want to unionize, you have an absolute right to do that. My dad was in the union, but you should have a secret ballot so you're not intimidated either, as Ms. Harper mentioned, either for or against. You can vote either way you want to. It's a mandated opt-in permission for each union member to utilize his or her union dues for any other activity other than collective bargaining, and direct all unionized workplaces to hold periodic secret ballot referendums to determine if employees wish to remain in their current union, since the majority of most members never voted on it. A safeguard to worker privacy by granting individuals the ability to opt out of sharing their personal information if they don't want to. And I could go on. There's more to this, but I'd like to ask a question to Mr. Todman, and this is I found interesting. A 2015 poll from the Opinion Research Corporation found that 81% of Democrats support the right to a secret ballot election, support a requirement that unions stand for periodic recertification, and support a requirement that unions receive opt-in permission from workers before using their dues on politics. Is this number surprising to you based on your experience representing employees around the country? Is your mic on?
Okay, sorry. These things represent fundamental American values. Secret ballot, not being forced to give money to organizations that you disagree with, having financial transparency with organizations that you're asked to support. All of these things are fundamental free speech, free association values. The Supreme Court in the Janus case just last term, and in a series of cases going back many decades, has recognized employees have the right to join unions and support unions, but also must have the equal right to not join, to refrain, to disassociate. And that's what we're talking about here. The right to join must include an equal right to refrain, because without that, then we're in Venezuela, let us say. So,
and Americans vote for the representation here, as you mentioned, every 2 years, and they're guaranteed access to a secret ballot when doing so. And this way, Americans can hold their congressional representatives accountable. In your opinion, does the secret ballot in periodic elections bring more accountability to unionized workplaces?
absolutely, because union officials will have to work to get the support of the employees they represent. Right now, if the employees have never voted, it's almost impossible for them to even get an election to determine whether the union has support or not. So the union officials have no real need to be accountable to the people they represent. But if there was automatic recertifications, they would have to work for that support.
I think, I kind of laugh about this, saying this tongue-in-cheek a little bit, but my wife claims she votes for me during these elections, but I don't know for sure because it's a secret ballot, and that way I can't intimidate her at the House to vote for me. I feel that strongly about it. I think of anything we do, we should guarantee every American the right to vote unintimidated and with a secret ballot. Madam Chair, thank you very much. I yield back.
Thank you, Dr. Rowe. I now recognize Representative Fudge.
Thank you very much, Madam Chair, and thank you all so much for being here. Ms. Harper from Ohio, welcome. Ms. Harper, there really is nothing that we can do to change the hearts and minds of the lowlifes who treated you the way they did. There are just some people who are despicable and mean, especially when you were just only trying to exercise your First Amendment rights, which people think only belong to certain types of people. But you have the same right to First Amendment speech as anybody else. The only problem I see today with labor laws is the people who want to destroy them. Those who have become more desperate and more aggressive in their effort to destroy people who work hard every day like you do. These are people who've probably never worked by the sweat of their brow or the bend of their back. So they have no idea what it means to protect workers. So the real problem with labor laws today is those who want to destroy them. And you know, it's interesting that we talked about misappropriation of funds. It's not confined to unions. We've had some people in the president's cabinet who had to leave because of questionable use of taxpayer money. So it's not confined to unions. People are put in jail every day. Corporations who misappropriate funds. It's not confined to unions. So I don't know what that was all about, but it just absolutely made no sense. Mr. Rosenfeld, we talk about right-to-work laws. Can you tell me if, in fact, right-to-work laws really were designed to keep unions out because they didn't want blacks and whites to have the same equal rights?
Thank you for that question, Congresswoman. So the history of right to work is interesting. It's pretty ugly. It goes back to one of kind of the key drivers behind these types of regulations was a Texas businessman, successful businessman, and white supremacist, Vance Muse, who promoted the rule because he ardently felt that unions brought people together, brought workers together across racial lines, and that was something he felt needed to be stopped in its tracks. And so it was no accident that the first states that adopted these types of regulations happened to be the states of the former Confederacy. Subsequent to that, since then, they've spread. Missouri, my home state, was the last state in which the legislature passed right-to-work legislation, but just back in the summer of 2018, 2/3 of Missourians voted against it. And that was pretty astonishing from, I think, the broader perspective of those who kind of fight for and fight against these types of regulations because, like many states, Missouri has seen dramatic declines in union representation.
Mr. Rosenfeld, let me cut you off. I got a very short period of time. Your answer is yes, though. Am I right? That
Correct.
okay, thank you. So are you surprised that today, with all of the heightened hate speech and all of the rhetoric we hear every day, that we're starting to see attacks on labor unions again?
No, but this has been a long-standing concern from many powerful interests, conservative business interests, to destroy organized labor in America. And for the last 30 or 40 years, they've proven quite successful.
So right to work really was born out of racism. Ms. Virk, can you talk just briefly about how the Supreme Court has undermined organizing and rights of immigrants?
I think you're probably the seminal case on that, Congressperson Fudge, is the Hoffman Plastics case that was decided, I believe, in the early 2000s. And what that case held was that even if an employer fired a worker for union activity, that if that worker was an undocumented immigrant, that worker not only had no right to reinstatement, but had no right even to back pay. And let me just pause here. The way that the board calculates back pay is that they take the wages that the employer paid and then they subtract any wages that the employee earned in the interim period. So the employer essentially gets the benefit of employees going out and seeking work to keep body and soul together while they've been unlawfully discharged from the employer. And what that Supreme Court ruling, I think, has really done is discourage even further undocumented immigrants from organizing, and has encouraged employers to use immigration status as a weapon during organizing campaigns. And I can go into further detail about that.
Well, my time is running out. I would just say that we find ourselves in a position that in this country, the more things change, the more they stay the same. Thank you very much, Madam Chair. I yield back.
I'll recognize the esteemed ranking member of the Education Committee, Education and Labor Committee, Dr. Fox.
Thank you, Madam Chairman. Mr. Taubman, one of the primary purposes of the National Labor Relations Act, NLRA, is to protect the rights of employees. But it appears much of the law as written assumes that workers benefit from everything a union does and that every worker agrees with the decisions of the union. Would you agree with that characterization of the NLRA? And from your experience, is this view accurate?
Sorry. Thank you, Congresswoman. That's a fantastic question, because workers are not monolithic and workers are not widgets. Workers are individual human beings who bring their own experiences and their own talents to the workplace. And in answer to your question, if unions do such great work and all workers benefit, you would think that all workers would want to join. But in fact, that's not the case, because workers see that the benefit is not necessarily true to them. If you're a top shelf worker with specific skills, you may find yourself being held back by the union contract. If you are a young worker who wants more pay and is not that concerned about your pension, you may find your economic priorities are turned upside down by a union contract and union representation. And those are just a few examples. So the bottom line is that individual workers should be treated as individuals, free to make their own decisions about what organizations they join or support.
Thank you. Mr. Taubman, 43% of union households voted Republican for president in 2016, despite roughly 90% of union political donations going to support Democrats. What protections exist for workers to ensure they aren't forced to fund union politics against their will, and how might we amend the NLRA to provide stronger free speech protections to workers?
Well, of course, in right-to-work states, employees have the free choice to not join and to opt out. That's how they exercise their right to protect themselves from funding causes and candidates they do not support. In forced unionism states, employees are forced to pay as a condition of employment. And up until just a few weeks ago, the National Labor Relations Board had ruled that employees must fund union lobbying campaigns as a condition of employment. That was a ruling from the Obama National Labor Relations Board in 2012. And only just now have we gotten a reversal of that in a case called Kent Hospital, where the National Labor Relations Board said employees do not have to fund political campaigns. But yet it took a nurse, Jeanette Geary, a 9-year legal battle to get that ruling. So the protections for workers who don't want to support political and ideological causes they oppose needs to be strengthened greatly.
Thank you for that. It's been mentioned more than once here that 90% of workers represented by a union today have never actually voted for that union itself to represent them. So we've created a system of inherited rather than elected representation. Why is this the case, and how might Congress amend the NLRA to remedy this problem?
I mean, this could be done easily by passing legislation to have automatic periodic recertifications. That's all that would be needed. All of the elected officials in this room face the voters every 2 years. Senators face the voters every 6 years. I would leave it up to this committee and to Congress to determine what the appropriate interval should be, but it seems only fair that workers be asked periodically, do you continue to support the union that represents you?
Thank you. Mr. Taubman, the last time Democrats held the House majority, they voted to deny workers the right to a secret ballot for union elections, a protection guaranteed to every American when they vote for their elected officials, including members of Congress. Can you briefly explain the difference between the current card check process, secret ballot voting, and the card check scheme previously passed by the Democrats? Why is the right to a secret ballot so important in union elections?
My experience representing workers, and I'm told this by many, is that when there's a card check campaign going on, they are coerced, they are harassed, union officials come to their home, they're bribed, we'll take you out for dinners, we'll do whatever it takes to get you to sign a card, which counts as a vote, whatever it takes. That's part of the union organizer's manual. Get that signature, whatever it takes. But that's not how a secret ballot election works. That's not how free elections work. You walk into a booth, you close the curtain, you vote. Why unions are so afraid of a secret ballot election is just startling to me.
Thank you for your indulgence, Madam Chairman. I thank all of our witnesses for being here today.
Thank you, Dr. Fox. Mr. Levin?
Thank you so much, Madam Chairwoman. Mr. Taubman, you're getting good at turning on your mic. I see that you don't like it when what you consider harassment when unions go to people's homes. So are you in favor of giving workers access, mandatory access to union organizers in the workplace so that they can have that access to the information? Yes or no?
Well, I believe that unions running organizing campaigns have access to.
You're wrong. I was a union organizer for years. Every employer that I tried to organize the workers at would arrest me if I came on the premises.
Well,
Mr. Taubman, I'm also really interested in your devotion to regular elections. Do you favor that all workers in the United States should have an opportunity every 2 years to vote on whether they wish to be represented by a union or not?
No, because
Why not?
Because there should be a showing of interest by the workers.
So you only favor mandatory elections for workers who choose to join a union or who have a union, but you're against elections for all workers.
Well, I gather from your question you're suggesting that workers be assigned a union.
No,
They have
just
no
whether they could, every 2 years, they could have an opportunity whether they wish to be represented by a union or not.
Which union? They're just,
Whichever union they want.
well, whatever union they want, but how would that work? They're going to be told, well, you're a truck driver, so we're going to assign you the team.
No one talked about assign. You mentioned that. Okay. So you're for mandatory elections every 2 years for workers who have a union, but you're against it for workers who don't have a union.
If the union can organize and file for an election, which they seem to have every right to do, they only need 30% of the cards under current law.
All right, thank you.
Then they can.
Thank you.
file for an
Mr.
election.
Rosenfeld, you talked about the spillover effect when workers join unions in terms of how it affects non-union workers. Can you explain more about what the spillover effect is?
Sure. So spillover effects occur through a variety of channels. I'll be as brief as possible.
Yeah,
One
that's
is
okay.
a
Go ahead.
well-documented union threat effect. So if you're a non-union plant next to an organized plant, you might raise your pay and benefits to match the unionized plant's pay and benefits to avoid a unionization drive. So that's been going back generations of research documenting that. But also, we know from how pay setting occurs that industry leaders oftentimes set pay standards for the rest of the industry. And when organized labor was strong, many industry leaders were unionized. And so that means that union and non-union plants alike looked to them when it came to setting wages and benefits.
So I think in 1947 and 1952, 35% of workers in the private sector were unionized. Today it's 6%. 62% of Americans have a positive impact of unions. If we had a free market for union organization, we might have about 30%, according to Richard Freeman's research and others. What impact might it have on the United States economy, and especially on often marginalized workers, women, workers of color, immigrant workers, if there was a real free market for unionization and we got back up to something like 30% of workers being unionized?
That's a great question. I think first and foremost, you'd see, we've For decades, post-World War II decades, we had productivity in the broader economy tracking average workers' wages.
Almost exactly, yeah.
Exactly. And then there was a great divergence. And for a while, that kind of flummoxed economists and others who study this issue. I think there's growing consensus that one of the key reasons has been the dramatic loss of worker power. So if we were to bring density rates up 20%, 30%, I think you'd see that gap start to close again, and your average workers, including racial and ethnic minorities, would start to benefit from broader growth in the economy.
And so you think it would have do you think it might have any significant impact on the problem of income and wealth inequality in our country, which has gotten much worse in the same period as union density has declined?
I think if you look in this country's own history, you look across the developed world today, there's no question that raising density rates is a key factor in terms of reducing the types of disparities you're discussing.
Okay, thank you. Ms. Vert, can you talk about some of the ways that employers can stall elections?
Can stall elections?
Stall elections, yeah.
Yes. Under the current rules that have been adopted by the board several years ago, it's somewhat more difficult, but the main way that they can continue to do it is by contesting the composition of what they call the bargaining unit, which is the group of workers who's entitled to vote for union representation. And employers often do this by adding groups of employees who may bear only an attenuated relationship to the group of employees who wants to unionize and who the union has been working with. And employers attempt to add those additional groups into the group that will have the ability to vote on unionization in the workplace.
And the 2014 rules somewhat mitigated the problem. How did they do that?
They somewhat mitigated the problem by adopting a set of presumptions that if the number of employees who were to be added to the unit were less than a certain amount, then the board would simply go forward to an election. But it still is a substantial issue, partly because board doctrine, since the Trump administration appointees have a majority, has also decided some cases that make this additional adding in of additional groups into the bargaining unit by employers a much more routine practice. That case is called PCC structurals, I believe.
Okay.
Thank you.
My time's expired. Thank you, Madam Chairman.
Thank you. Mr. Allen?
Thank you very much, Madam Chairman. And my home state of Georgia is been named this best state to do business in the last 6 years. We have been a right-to-work state since 1947. The economy in Georgia, particularly in my district, is thriving. And of course, I was at a function just on Friday where we had 7,000 national Association of Building and Trades Unions members working at a nuclear power facility, the only one under construction in the country. And we had the president of the union there, the Secretary of Energy, the Secretary of Agriculture, the governor, and we were all thanking the president for this, helping us get to this point as far as the economy and helping us, America can now do big things again. And it's been an amazing turnaround, by the way, as far as production at that facility. And so I asked, how did you turn this thing around? And they said, we empowered the workers. And so what we've seen in business, I was in business for 35 years, and this business of this top-down, you do this, you do that, or you gonna be this, you gonna be that, without freedom is out of style in this country. It's out of style in the workplace. In other words, you got union, non-union, this, that, or the other. I mean, what I'm in favor of is empowering the worker. Ms. Harper, you shouldn't work for a company. I mean, with 7.5 million jobs open out there, there are companies that would love to have your services and would treat you as you should be treated. Every worker should be treated well. But the bottom line is, Georgia is doing something right. And obviously, the number one reason that a business locates anywhere, whether anywhere in the country, is skilled workforce. In fact, I told the president of the National Teamsters Building and Trades Union, I said, you skill up a workforce, and I guarantee you, because in construction, we're all getting gray-headed. We don't have a lot of young people coming into to our trade. So you train folks up, and there'll be plenty of jobs out there. But according to the data, right-to-work states' household employment growth was more than double than that of forced union states. Again, you have to be this, you have to be that. In Georgia, we can be whatever you need to be, okay? Why might a right-to-work state be a more attractive, say, for entrepreneurs and workers alike? I mean, what does your research indicate there? Yes, sir, Mr. Tubman.
Well, you know, when you talked about this gathering of the building trades there in Georgia, the fact of the matter is unions can exist well and can thrive in right-to-work states because they have a workforce that has voluntarily joined, that sees benefit in it. In fact, there's a lot of union organizing going on in right-to-work states. So there's just a recognition that employees have free choice and employees can thrive in right-to-work states. And that's all that we are asking for, is the free choice so that people can thrive in their workplace and their jobs and not be forced into a private organization. And when you have that, unions, if they represent people, have to be more responsive.
In which, again, which makes it a better fit for businesses that are looking for, you know, a location. Particularly, of course, foreign investment has grown substantially in Georgia because of that. But as far as the thing we have in this country that I hold so dear is the freedom to choose your job, your profession, the skill, and that sort of thing. And of course, and nobody's in a caste system. You're not stuck. I mean, what is it that we can do to bring both sides together and say this is the best solution for both all workers? Mr. Tubman.
Well, to me, it's obvious that right to work is just a free principle that people get to choose and that workers thrive. I mean, how you convince a union that exists on coercion and compulsion to try something different, I don't know and I can't answer. But the fact of the matter is unions exist and exist well in right to work states if they provide benefits that their membership chooses to join.
They're doing great in Georgia.
Thank you. I'll recognize Mr. Norcross.
Thank you, Madam Chairwoman, and thank you for holding this hearing, something near and dear to my heart, and worked in close to 40 years dealing with labor board, labor issues back in New Jersey, Philadelphia region. About 30 years ago, Ninth Court of Appeals held that it was irrational for the board to presume that a union was making an illegal threat unless the union proclaims that its picketing would be conducted in a lawful manner. In spite of this, in a recent case involving the IBEW, a Republican-controlled board ruled that a union, the IBEW in this case, breaks the law if it merely notifies Company B that it might be picketing against A. Sounds very confusing until you've actually lived this life, which I have been involved in. This ruling was so off base that it led 3 Republican appointees on the D.C. Circuit to rule that the Nlrb approach to this issue was without foundation in the Act, relevant to this case and the general legal principles. So what did the board do? It doubled down and issued another opinion defying the D.C. court. All the local union did in this case was provide a courtesy copy to the Las Vegas Convention Center and Visitors Authority that the Building and Construction Trades Councils was requesting the authority to engage in area standards picketing, something I was involved in literally for decades. Nothing here leads us to believe what the NLRB is making this decision. So, Ms. Burke, where do you see this going? Such defiance of the court not the committee itself, but the court. Where
As
do we
I-
go next? Not follow any precedent, any law?
Well, as I understand it, the Labor Board, and I don't know if it's unique among agencies, but it's certainly the agency that I'm familiar with, that it has a policy of what they call non-acquiescence, which, as I understand it, it means that in any given case, if a court of appeals reverses a board order, the board is compelled to follow the court in that particular case. But it does not, or it is privileged not, to follow that same rule that the court has set down in any other similar case. This is just one of the ways in which the board's jurisprudence ends up being conflicting and confusing and often internally contradictory. Is there a cure for it, or is there an end in sight? I'm not sure, but I do know that.
I think there's a cure, and it's something that we can do. But this is the point. Precedent, the rule of law, the very basis for our country. And yet, 3 individuals decide that they are now the law and will change it in any way they see fit. This is a primary area of focus that I think we as a committee should look at when we start making recommendations and writing some of the changes that are really needed. We thank you very much for your input in this, and something that this is just one of many issues that has been abused. With that, I yield back the balance of my time.
Thank you, Mr. Norcross. Congressman Banks, recognize.
Thank you, Madam Chairwoman. Mr. Taubman, in 2014, the National Labor Relations Board instituted what has become known as the ambush election rule, which you mentioned in your testimony. Can you explain to the members of this committee what that rule is and how it infringes upon workers' rights?
Well, the ambush election rules allow that once a union files a petition, that the election will be held very, very quickly, meaning there's no time for debate among the workforce, there's no time for employees to educate themselves, and for employers who have Section 8C free speech rights, there's no time for them to have input into it. You know, I heard some testimony about employers not being parties to these things. There's actually 3 parties to an Nlrb election. There's unions, there's employers, and there's workers. And all of these people should have free speech rights in the workplace. And so the ambush election rules curtailed all of that and made it impossible for there to be a real debate. And at the same time, it didn't apply, the ambush rules did not apply to a decertification. So if employees said, we want to choose to vote to get rid of the current union, suddenly it was all subject to being blocked and delayed. Because those
Can I stop you there and ask you, what is the current status of the rule?
The current status of the rule is that the current Nlrb is in the process of a rule-making program looking at changing some or all of that rule. But it's just, these things take a long time when you deal with rulemaking, because there has to be notice and comment. The board, when they issue the final rules, has to respond to all of these comments. So you're looking at a process that often goes years.
Okay. Moving on to a different issue. A 2015 poll from the Opinion Research Corporation found that 81% of Democrats support the right to a secret ballot election. They support a requirement that unions stand for periodic recertification and support a requirement that unions receive opt-in permission from workers before using their dues on politics. Is this number surprising to you based on your experience representing employees across the country?
Right. Again, these are all basic free speech, free association principles. I think if you ask Americans what do they think about secret ballots and free speech, which frankly is under attack in many parts of this country, most Americans support free speech and the right of people to organize together, but the equal right to not join, to not organize, to refrain. You can't have the right of association without having the right of non-association. The Supreme Court's held this for years.
So it doesn't sound like you're surprised. Let's move on to another issue. As a co-author of Indiana's very successful right-to-work law, I've noticed that a lot of opposition to right-to-work laws come from the belief that reduced union power will lead to lower wages. There are a number of studies that make this claim, but these studies often fail to account for the significant difference in cost of living across the states. In fact, the Missouri Economic Research and Information Center notes that right-to-work states have a cost of living that is 6.5% below the national average as of 2016. When taking this difference fully into account, disposable per capita income was $2,400 higher in right-to-work states than those with forced union states, according to 2016 data from the Bureau of Economic Research. Can you talk about why income may be higher in right-to-work states when the common wisdom suggests they would be lower?
Right. So I'm not an economist. Talking about the statistics is not my forte. I'm a lawyer that represents individual employees. But to me, it's just common sense that when you have a workforce that has free choice, that's mobile, that their talents are rewarded based upon who they are as an individual and not treating workers as widgets or machines that get put into collective bargaining units, that you're going to have more freedom and you're going to have more economic growth. And that's why right-to-work states lead the country in economic growth.
Thank you. My time has expired.
Thank you. Congressman Courtney.
Thank you, Madam Chairwoman, and definitely for holding this hearing this morning. Mr. Rosenfeld, I'd like to expand on some of your comments regarding the role that unions play in reducing inequality, ensuring that wages rise with worker productivity, and maybe in a little different sort of realm than might have been discussed this morning, which is, right now, I think almost any member going anywhere in the country is going to hear a hue and cry about the skills gap and the need for getting workforce training and just a way of imparting, whether it's manufacturing, healthcare, finance, I mean, the list goes on and on. In Connecticut, where we do have a workforce with 16% union participation, we've actually seen some really impressive efforts between management and unions, particularly in the area of defense manufacturing. Again, as we see baby boomers leaving in big numbers from the workforce and obviously trying to get millennials sort of up to speed. The apprenticeship program, which has been going on down at the Electric Boat Shipyard, which is now about 12,000 strong in terms of the workforce, and it's going to continue growing over the next 2 or 3 years with the Navy shipbuilding plan. That, again, has been incredibly successful in terms of really accelerating people through the skills acquisition process, if you want to call it that. They also continue with active learning centers for people who are actually in the yard, so that, again, this is just an ongoing process. And again, it's done through a management labor sort of agreement in terms of how it operates. We also, up in Pomfret, Connecticut, have the Laborers International Union of North America, which actually has their New England Training Academy for the building trades and construction. So again, I was wondering if you could talk a little bit, if you could, about sort of the ancillary benefits of collective bargaining in terms of really addressing issues that are common to both management and labor.
Yeah, I think that's a great question, and unions' role in kind of fostering training, workforce development programs oftentimes gets overshadowed in these highly politicized debates. But it's real, it's there, and we see successful efforts across the country. In Connecticut, there's been good research done on manufacturing in Wisconsin and Michigan as well, where they've had kind of successful training programs working hand in hand with management about how to upskill the workforce. And I think that's a nice way of saying that not only do unions help close the gap between rising productivity and average worker wages, but they also help bump productivity in the first place. And that's, I will say, an area that gets less attention, but probably needs more.
Thank you. Again, and I think having that, sort of bottom-up communication about, ways that new technologies are being introduced in terms of just, workplace methods and production you know, again, has just been very successful in terms of, you know, they just commissioned the USS South Dakota, again, built ahead of schedule. The workforce is now 51% millennial. And, you know, if you go back just 3 or 4 years ago, it was about a quarter. So this thing is happening very quickly in terms of just the change in the workforce. And there's just no question that the union management arrangements to really kind of mentor these young folks coming in through the Metal Trades Council and the United Auto Workers has just really been a tremendous success.
Yeah, I wouldn't disagree at all, and we see that kind of overseas in places that still retain strong manufacturing bases, Germany, Denmark, and the like, that unions, one of their key roles is helping in this kind of upskilling and bringing in kind of new workers to replace those who are now facing retirement age.
Thank you. I would be remiss if I didn't mention that Mr. Scott's district is also seeing that same kind of change that's happening in the workforce, and this really is the question of the day for our economies. It's just whether we're going to have the folks skilled up to take on these opportunities. With that, I yield back.
Thank you. I now recognize the esteemed chair of the Education and Labor Committee, Chairman Scott.
Thank you, Madam Chair. Mr. Rosenfeld, we've heard a suggestion that unions hold people back. Can you show the difference between compensation of union members and non-union members? Does it make a difference?
Sure. The union wage premium, well documented in now decades worth of studies, averages about 15 to 20%. So that means you take a worker who belongs to a labor union and an otherwise similar non-worker, similar in all sorts of characteristics that affect people's pay, the union member earns on average 15 to 20% more than the non-member.
Likelihood of a pension or employer-provided health care?
Absolutely. So once you start factoring in benefits, the divergence grows. Likelihood of having employer-provided health care is much higher among the union members, and certainly having a pension much higher among union members, and certainly having a defined benefit pension much higher among the union members.
Thank you. Ms. Verk, can you tell us why a private right of action is important?
A private right of action to enforce the National Labor Relations Act protections?
Right.
Right now, I believe that the only private right of action that exists for enforcing any of the protections under the Act is an action to enforce the duty of fair representation, which is an action that an individual member can bring against a union. There are, to my knowledge, no other provisions of the Act, including the right to be free from illegal coercion, the right not to be fired for engaging in union activity, the right to bargain collectively. All of those rights are only enforceable and exclusively enforceable through the board's own processes. Certainly, we've seen that in other situations, having a private right of action does develop a body of law and provides certain remedial measures that might not be available under an agency statute. I'm obviously not here as a policy maker, but it's something that certainly this body could consider as an effective way to provide a remedy.
Could you say a word about whether or not it's important to have injunctive relief, excuse me, and potential reinstatement during litigation?
Really, nothing could be more critical than having quick relief for when an individual, such as Ms. Harper, is fired for union activity. This often happens. It happens in not just isolated instances, but in a substantial percentage of campaigns to organize. Individuals who take the lead and who come out to their employers, as it were, as union supporters, end up being suspended, fired, and targeted. And it's not just that worker who is hurt, it is all the other workers who wish to have a union who see that happen and are reminded once again of the complete and utter coercive authority of their employer, what their employer can do to them, and having an injunctive relief that was not just available but mandatory in those cases would be a critical step.
And can you say a word about the deterrent effect of civil penalties and whether the civil penalties are sufficient today?
Well, as I understand it, there really are no civil penalties under the National Labor Relations Act. As I said, many of the wrongs that are found by the board are cured or supposedly cured only by a notice posting, literally a piece of paper up in the shop saying, go forth and don't do it again. This is really not a meaningful remedy. Almost every other statute that I can think of in this subject area and in many others has civil penalties attached to it for the basic reason that, again, we provide consequences for violating those rights that we believe to be important.
There's a concept of joint employer where you're at a temp agency and working at an agency, and there's a question of which one you can negotiate with. Why is it important to be able to negotiate with whoever is actually controlling the conditions and terms and conditions of employment?
Well, because those are the entities, just to state the obvious, that have the ability to affect an employee's terms and conditions of employment. If an employee is going to have a meaningful right to bargain collectively, they have to have the right entities across the table from them when they do that.
And why is it important to have a first contract? What happens on the first contract, and does that need to be changed?
Right now, when people organize, they choose a union, they jump through all of the hoops that are required of them. There's no incentive for an employer to reach a contract with the employees. In many cases, what happens is employers stall that process, and in the end of the day, even though workers have voted overwhelmingly to unionize, they never get a contract. I would suggest that one of the remedial measures that this body could take into account would be to have some process by which, if a contract is not reached after a certain period of bargaining has expired, that there be a neutral process by which an initial contract could be reached between the parties or facilitated through mediation or arbitration.
Thank you. Thank you, Madam Chair.
Thank you. Before recognizing the ranking member for his closing statement, I ask unanimous consent to enter the following materials into the record. A letter from the International Union of Painters and Allied Trades, without objection. I now recognize the distinguished ranking member, Mr. Wahlberg, for his closing statement.
I thank you, Madam Chairwoman, and appreciate the hearing. It's always worthwhile to discuss things that we may assume have been talked to death. Sometimes we forget that and we don't get the reality. So thank you for this. You've almost persuaded me to start an organizing petition for the minority. If we can get a union in place for the minority, I think we could have. Don't worry, I'm not going to. You're still treating me fine. I used to maybe drive my kids nuts, especially in their teenage years when they would come and talk to my wife. Well, first they'd talk to me, and then they'd go to my wife because they could get a better answer there about the dating process and what was going on and the romantic issues that were taking place in their life. And I would respond to them and say, well, that's the dance of the courtship. And so it got to a point in time in their life where anytime they approached me and I thought it was going to be the dance of the courtship, and they knew it exactly what I was saying. It's not an easy dance. It takes two people, it takes some other factors at times, and it just doesn't seem to work out in every case the exact way you want it at that point in time. But somehow, each and every one of them got through it, as their mother and father did as well, in that dance of the courtship. And so there's maybe a dance of the workplace, if I want to kind of apply that. There is a dance of the workplace. Nothing's perfect in a workplace, and sadly, as Ms. Harper so clearly illustrated for us today, there are still a few monster mashes going on as well in those workplaces that need to be taken care of, and that we have put in place rules and laws, agencies that are supposed to be taking care of that. And in some cases, they are. In some cases, we miss those things, and certainly we want to take those seriously, and especially when it relates to the life of an individual in the workplace. And Congress is responsible for defining and chaperoning this dance, as it were, It's our responsibility, the workplace miracle that has made America normally the greatest and most productive place to live and work in the entire world. I don't think there's a debate on that. And with our mistakes, we've remedied many of those. We've moved forward. And the unions and the management, the employees and the owners have all been a part of that over the course of time. And I don't want to give up on it, Madam Chairwoman. And so I, again, appreciate this hearing. I believe that any effort that takes the employer-employee scale out of balance puts everything out of sync. That scale has to remain in balance to make it work. And that's our responsibility, along with the workplace as well. Sadly, the results, if this imbalance takes place, can include abuse, it can include scandal, it can include fraud, lack of transparency, fear, and economic failure, both in individuals' household life as well as in a business's life as well, if we're not careful. We've come a long way to turn back now. While there are dark corners in most every room, there is irrefutable evidence that workers enjoy free choice better than not. You just have to look at Michigan for that. We can do all of the studies we want and put all of the data that we can find to put in that some cases, sadly, makes a point that we want to make. But when you look at the laboratory of life experience or the dance of the workplace at times in a state like Michigan that I'm privileged to represent, free choice of free individuals making informed decisions and then having the regulations and rules in place that meet the need of the place and time that we find ourselves works best. Michigan hasn't seen a decline in union membership and an actual increase in middle-class pay through coercion. Those are the facts in Michigan today, and I want to see them continue. And so that means that we work together in a light touch approach as necessary. If there is a heavy touch that is absolutely required, that's one thing. But to keep that scale, so there is always that creative tension, and in most of the businesses I go into, there is that creative tension where the employer knows that I'm at this state right now because I've taken care of my employees. And all I need to do is let some of those lights go out and the air conditioning fan go out and a number of things take place and lockouts get left open and unrepaired, and I've got a problem in my hands. I think that's productive. And I want to be part of that, and I thank the panel for being here today to cause us to think through those issues, and I yield back.
Thank you, Mr. Wahlberg, and we continue on our path together. I'll now recognize myself for the purpose of making my closing statement. Thank you again to all of our witnesses for your testimonies today. Today we heard how weak labor laws have failed to safeguard the human right to join a union. Routine violations of the right to organize suppress wages and deny workers the opportunity to negotiate for their fair share of the wealth they create. We heard from Dr. Rosenfeld how the decline of union membership hurts all workers and how unions can close the wage gaps for women and people of color. We heard from Ms. Harper how difficult it is to organize a union in the face of employer resistance. Ms. Harper is one of many courageous Americans who stood up for their right to organize a union and was unfairly targeted. As our witnesses have made clear, Congress must act now to stop violations of workers' rights and reverse decades of wage stagnation and income inequality. I thank my colleagues for an informative hearing. I thank the witnesses for coming, and I yield back my time. If there is no further business, without objection, the committee stands adjourned. Thank you for coming. Thank you. Thank you so much. Thank